2:42 a.m. I've still been working on putting these little videos together and also being with my kids a bit. And you can hear the creaky floor. Okay, so I'm going to just pop in. I think this is going to be the only part where I'm going to talk in this video, which is to say I strongly disagree with the ruling. The lighting is very weird, just showing you. I intensely disagree with the ruling that Donald Trump is still eligible to be on the ballot. I can't believe it. I can't believe that he can be a 34 convicted felon and be on the ballot. I can't believe that he was found legally liable in 2 civil cases. 2, not 1, but 2. Held responsible to pay $88 million, plus there's other cases, and, the whole insurrection thing. So I just am shocked that he is still on the ballot. Now I'm going to play the video.
The exact text of the preamble, the articles, the 27 amendments, and the exact wording regarding the separation of church and state.
catlovedreamingpeach.com.
The exact text of the preamble, the articles, the 27 amendments, and the exact wording regarding the separation of church and state. Here's the text for each part. Preamble to the Constitution of the United States. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. The 27 amendments to the Constitution of the United States. First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Third Amendment. No soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law. Nor shall private property be taken for public use, without just compensation. Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. 11th Amendment. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. 12th Amendment. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president. And they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority. Then from the persons having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately, by ballot, the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes as vice president shall be the vice president. But if there should remain 2 or more who have equal votes for vice president, the Senate shall choose from them by ballot the vice president. 13th Amendment. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. 14th Amendment. Section 1. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, Representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath, as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may by a vote of 2/3 of each House, remove such disability. Section 4. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article. 15th Amendment. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 16th Amendment. The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years. And each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen. 17th Amendment, Conted. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. 18th Amendment. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territory subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. 19th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. 20th Amendment. Section 1. The terms of the President and the Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3rd day of January, of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. Section 3. If, at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified. Section 4. The Congress may by law provide for the case wherein neither a President-elect nor a Vice President-elect shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified. Section 5. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. 21st Amendment. Section 1. The 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors, and violation of the laws thereof, is hereby prohibited. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. 22nd Amendment. Section 1. No person shall be elected to the office of the President more than twice, and no person who has held the office of President, or acted as President, for more than 2 years of a term to which some other person was elected President shall be elected to the office of President more than once. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. 23rd Amendment. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of President and Vice President equal to the whole number of senators and representatives to which the district would be entitled if it were a state, but in no event more than the least populous state. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 24th Amendment. Section 1. The right of citizens of the United States to vote in any primary or other election for President or Vice President, for electors for President or Vice President, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 25th Amendment. Section 1. In case of the removal of the President from office or of his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon Congress shall decide the issue, assembling within 48 hours for that purpose if not in session. If Congress, within 21 days after receipt of the latter written declaration, or, if Congress is not in session, within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President, otherwise, the President shall resume the powers and duties of his office. 26th Amendment. Section 1. The right of citizens of the United States, who are 18 years of age or older, to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 27th Amendment. No law, varying the compensation for the services of the senators and representatives, shall take effect, until an election of representatives shall have intervened. Exact wording regarding the separation of church and state. The phrase separation of church and state is not explicitly stated in the Constitution but is derived from the interpretation of the First Amendment, specifically the Establishment Clause. First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof. The concept of separation of church and state was famously articulated by President Thomas Jefferson in his letter to the Danbury Baptists in 1802, where he referred to the Establishment Clause as creating a wall of separation between church and state. This interpretation has been reinforced through various Supreme Court rulings over the years. The part about the insurrection doesn't that disqualify Donald Trump from running for office. The portion of the 14th Amendment relevant to insurrection is Section 3. No person shall be a senator or representative in Congress, or elector of President and Vice President, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath, as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may by a vote of 2/3 of each house, remove such disability. This section of the 14th Amendment was designed to address those who had participated in the insurrection against the Union during the Civil War. It prohibits such individuals from holding office unless Congress removes this disqualification by a 2/3 vote in both the House and Senate. As of now, Donald Trump has not been disqualified from running for office under this provision. There has been significant legal and political debate about whether his actions related to the January 6, 2021, Capitol riot constitute engagement in insurrection under the amendment. This interpretation would ultimately require judicial review and congressional action to determine whether it applies to him and whether he should be disqualified from holding office. Has there been any judicial review or congressional action regarding this? Sunday, August 25, 2024. As of now, there has not been a formal judicial ruling or congressional action specifically disqualifying Donald Trump from running for office under the 14th Amendment's insurrection clause. Here's a summary of the current status. Judicial review. There have been several legal challenges and discussions about whether Trump's actions related to the January 6th Capitol riot fall under the insurrection clause of the 14th Amendment. However, no court has definitively ruled on this issue as it pertains to his eligibility to run for office. Some legal scholars and commentators have debated the application of this clause, but it remains an unresolved question in the courts. Congressional action. Congress has not taken any action to disqualify Trump from holding office under the insurrection clause. For such a disqualification to occur, Congress would need to pass a resolution by a two-thirds majority in both the House of Representatives and the Senate. There have been no significant moves within Congress to pursue this route as of the latest updates. If there were any new developments or actions taken in relation to this issue, they would likely be covered in the news and legal analyses.
Well, excuse the fan and the air conditioner, but this guy's a blowhard, so it's appropriate. I'm just screenshotting some articles that were written and posted, and then I actually went ahead and screen recorded about 35 or 40 minutes of the actual hearing that happened. So I started watching it. It was many hours, but I tried to capture some of the most important parts. I personally believe that this man is incredibly dangerous, and the people who are backing him are incredibly dangerous as well. So I do believe that he absolutely should be disqualified. So here's some articles. You can go ahead and read them if you'd like. I'm going to share the link for the video that I share later on in this video, and feel free to watch the whole thing or just go to the PBS and watch the entire full multi-hour, it's multi-days, many days. This is just showing the map where states wanted to disqualify him from the ticket, but ultimately it was shot down for now. And I do believe it'll come back up, but we'll see what's going to happen.
Trump disqualification tracker. Almost immediately after January 6, 2021, legal commentators began debating whether Section 3 of the 14th Amendment would disqualify former President Donald Trump from running in the 2024 presidential election. They debated whether or not Section 3 applies to a former president, whether it is self-executing, and whether January 6th could be considered an insurrection or rebellion. Since then, the issue became less abstract, though no less contentious. In February 2021, the U.S. Senate acquitted Trump of an impeachment article for inciting insurrection, but with a bipartisan majority of the Senate voting to convict. Section 3 challenges have been mounted against several legislators, and one state-level county commissioner who participated in the attack was successfully ousted from his post under that provision. At the end of 2022, the House Select Committee on the Jan. 6 attack on the Capitol made the argument that Trump did inspire an insurrection, referring him to the Justice Department for prosecution under multiple criminal statutes, including one prohibiting insurrection. The special counsel's office has since brought a criminal case in Washington, D.C. charging Trump for his role in the Jan. 6 attack. And some prominent legal conservatives made the case for a strong, originalist reading of Section 3 that they argue would apply to Trump, immediately disqualifying him from office. Beginning in winter 2023, voters and advocacy groups have brought Section 3 challenges in courts across the country, attempting to block Trump's name from appearing on ballots for state primaries and caucuses before the general election begins. As Lawfare tracked and represented in the above map and table below. After Colorado became the first state in the nation to take Trump off its presidential primary ballot in Anderson et. Al v. Griswold, the question reached the Supreme Court in Trump's appeal of the decision in Trump v. Anderson, the docket for which Lawfare tracked and remains below, after hearing oral argument on February 8. The Supreme Court ruled on March 4 that Trump could not be disqualified from Colorado's presidential primary ballot under Section 3 without congressional action. Read Lawfare's analysis on the decision. That decision has effectively ended the array of challenges to Trump's ballot eligibility. While we have stopped tracking state-by-state Section 3 challenges in light of the court's ruling in Trump v. Anderson, the story is not yet over. Below you will find Lawfare's past and continuing coverage of the legal and policy implications surrounding Trump Section 3 challenges and primary source documents, analysis, and resources. The Trump Disqualification Tracker was created by Chaim and Hahn with Caleb Benjamin on October 30, 2023. The litigation tracker portion of the project was last updated and edited by Hahn, Anna Bauer, Matt Gluck, Tyler McBrien, and Roger Parloff on March 4, 2024. Lawfare analysis on Section 3. Can Congress disqualify Trump after the Supreme Court Section 3 ruling? The dueling opinions for the 9-0 decision support two opposing interpretations on this crucial question. The Lawfare Podcast, unpacking the Supreme Court's 14th Amendment ruling. What are the implications of the recent SCOTUS ruling on Section 3? What the Supreme Court got wrong in the Trump Section 3 case. The court botched the legal reasoning and relied heavily on dubious policy arguments. Section 3 disqualification answers, and many more questions. The Supreme Court's ruling in Trump v. Anderson punts several questions about disqualifying Donald Trump under Section 3 of the 14th Amendment. Supreme Court keeps Trump on the Colorado ballot. In a 9-0 ruling, the Supreme Court ruled that the Colorado Supreme Court erred in removing former President Donald Trump from the state's presidential primary ballot. Trump disqualified from Illinois primary ballot. Illinois is the third state in which the former president has been found ineligible for the presidential primary ballot. Lawfare Live, Trump's Trials and Tribulations, Friday, February 16th. Join the Lawfare team for a discussion of the trials of Donald Trump. The Lawfare Podcast, Trump's Trials and Tribulations, Supreme Court Oral Arguments in the Trump Disqualification Case. What happened at the Supreme Court yesterday? Trump versus Anderson, SCOTUS hears Trump disqualification arguments. What the advocates argued, what the justices asked, and where the court may go from here. Section 3 at the U.S. Supreme Court. Anderson et al. v. Griswold et al. Was originally filed on September 9, 2023 by 6 Colorado voters against Jena Griswold, in her official capacity as Colorado Secretary of State, and Donald J. Trump. On November 17, in Denver District Court, Judge Sarah B. Wallace dismissed the petitioner's suit, but determined that Trump engaged in insurrection. On December 19, the Colorado Supreme Court ruled on appeal that former President Donald Trump is disqualified from being president under Section 3 of the 14th Amendment. On March 4, 2024, the Supreme Court ruled that Section 3 of the 14th Amendment could not be used to remove former President Donald Trump from Colorado's presidential primary ballot without further congressional action. 2 months prior, the Supreme Court had granted Trump's petition for it to review the Colorado Supreme Court's decision removing him from the state's primary ballot. Trump and the Colorado Republican Party filed petitions for writ of certiorari on January 3, 2024 and December 27, 2023, respectively. Oral argument in Trump v. Anderson was on February 8. Lawfare tracked the Supreme Court's docket on the right. The docket cases we watched. Colorado, Anderson et al. v. Griswold et al. Was filed on September 9, 2023 by 6 Colorado voters against Jena Griswold, in her official capacity as Colorado Secretary of State, and Donald J. Trump. On November 17, in Denver District Court, Judge Sarah B. Wallace dismissed the petitioner's suit, but determined that Trump engaged in insurrection. On December 19, the Colorado Supreme Court ruled on appeal that former President Donald Trump is disqualified from being president under Section 3 of the 14th Amendment. Illinois, on February 28, Illinois Circuit Judge Tracy R. Porter ruled that Donald Trump is ineligible to be listed on the Illinois primary ballot due to his role in January 6, making Illinois the third state in which Trump was disqualified under Section 3. Maine, on December 28, 2023 Maine Secretary of State Shenna Bellows ruled pursuant to state election laws, in response to 3 administrative challenges, that Trump is disqualified from the ballot, making Maine the second state to disqualify the former president under Section 3 of the 14th Amendment. The decision was automatically stayed pending Trump's appeal to Maine Superior Court. Click on Trump v. Bellows under the state of Maine for more information. Minnesota, Groh et al. v. Simon was filed on September 12, 2023 by 8 Minnesota voters against Steve Simon in his official capacity as Minnesota Secretary of State. On November 8, the Minnesota Supreme Court dismissed the petition, but added that the plaintiffs could bring a new petition regarding the general election ballot following the upcoming Republican primaries. Michigan, Labrant et al. v. Benson was filed on September 29, 2023 by 4 Michigan voters against Jocelyn Benson in her official capacity as Michigan Secretary of State. On November 14. Judge James Redford of the Michigan Court of Claims dismissed the petition. Michigan voters appealed, and the State of Michigan Court of Appeals affirmed the Court of Claims decision on December 14. On December 27, the Michigan Supreme Court denied review of the Court of Appeals ruling. Accordingly, Trump may appear on the primary ballot. The Court of Appeals ruling did not preclude a renewed challenge to Trump's appearance on the general election ballot should he become the party's nominee.
Unfortunately, the Supreme Court, I do believe, is corrupt, especially with those MAGA cultists that he installed. And for now, they shot it down. They let him on the ballot, but hopefully things will right themselves
I want to start by thanking the Supreme Court for its unanimous decision today. It was a very important decision. We're very well crafted, and I think it will go a long way toward bringing our country together, which our country needs. And they worked long, they worked hard, and frankly, they worked very quickly on something that will be spoken about 100 years from now and 200 years from now. Extremely important. Essentially, you cannot take somebody out of a race because an opponent would like to have it that way. And it has nothing to do with the fact that it's the leading candidate, whether it was the leading candidate or a candidate that was well down on the totem pole. You cannot take somebody out of a race. The voters can take the person out of the race very quickly, but a court shouldn't be doing that, and the Supreme Court saw that very well. And I really do believe that will be a unifying factor, because while most states were thrilled to have me, there were some that didn't, and they didn't want that for political reasons. They didn't want that because of poll numbers, because the poll numbers are very good. We're beating President Biden in almost every poll. New York Times came out yesterday with a very big poll for us. So they didn't like that, and you can't do that. You can't do what they tried to do.
He really is truly a buffoon. So he's installed
Here is
bunch
information
of
from
judges
Wikipedia.
all over the place. They are currently trying to make some corrupt voting laws so that more and more people get disenfranchised from their votes. Hopefully these things will not have lasting repercussions, but it is definitely going to be a legal battle. And there are unfortunately quite a bit of MAGA cultists who are racist, misogynistic, xenophobic, Islamophobic, homophobic,
transphobic,
anti-Semitic, and on, basically hate-filled. Think of some type of hate,
gender fluid phobic,
and they're all about it. So that's really sad and despicable, and neo-Nazis like her are alive and well. There's a great video of Kamala Harris bringing this Brett Kavanaugh to shreds in a congressional hearing. And I don't know anything about that guy, but I know he's corrupt. So if you're interested in the screen recordings that I am going to add to here, then keep on watching.
I want to begin with some breaking news.
Thank you.
News at this hour. The Supreme Court ruling former President Donald Trump can stay on the ballot in Colorado.
All 9 justices ruled this morning in favor of Trump, and the results spread nationwide, including to Illinois, where a judge ruled Trump could not be on the ballot. ABC's Perry Russum is in Washington with the latest.
A day ahead of Super Tuesday, the Supreme Court unanimously ruling former President Trump can remain on the ballot. The case surrounded Colorado Supreme Court's decision to disqualify Trump from its primary ballot, citing Section 3 of the 14th Amendment. The section reads, no one who has taken an oath to support the Constitution and then engaged in insurrection can hold public office afterward. In today's decision, the justices writing, the Constitution empowers Congress to prescribe how those determinations are made. During oral arguments last month, both liberal and conservative justices signaled skepticism over Colorado's ruling.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States.
It doesn't seem like a state call.
Today's ruling has implications nationwide, as the Secretary of State in Maine also disqualified Trump from its ballot, and a judge in Illinois ruled Trump could not be on the ballot there.
I don't think there's any way for a state to try to circumvent this ruling. At this point, any action has to be in the hands of Congress, and that's what the court said pretty clearly.
Colorado's Secretary of State posting a statement expressing disappointment, adding Colorado should be able to bar oath-breaking insurrections from our ballot. Today, Trump calling the decision a big win for America. And as we mentioned, Colorado as the state starting all of this, Trump's name was kept on the ballot there during the course of the appeals process for those voting by mail. As of Friday, more than 800,000 people have already voted by mail. Perry Russom, ABC News, Washington.
To Trump v. Anderson per curiam President Trump's defeat in the 2020 presidential election. He disrupted the peaceful transfer of power by intentionally organizing and inciting the crowd that breached the Capitol as Congress met to certify the election results on January 6, 2021. One consequence of those actions, the respondents maintain, is that former President Trump is constitutionally ineligible to serve as president again. Their theory turns on Section 3 of the 14th Amendment. Section 3 provides, no person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath, as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. According to the respondents, Section 3 applies to the former president because after taking the presidential oath in 2017, he intentionally incited the breaching of the Capitol on January 6 in order to retain power. They claim that he is therefore not a qualified candidate, and that as a result, the Colorado Secretary of State may not place him on the primary ballot. See Colorado Rev. Stat. 1, 1, 113, 1, 1, 4, 1101, 1, 1, 4, 1201, 1, 4, 1203, 2, A, 1, 4, 1204, 2023. After a 5-day trial, the state district court found that former President Trump had engaged in insurrection within the meaning of Section 3, but nonetheless denied the respondents' petition. The court held that Section 3 did not apply because the presidency, which Section 3 does not mention by name, is not an office. Under the United
At lovedreamingpeach.com. At lovedreamingpeach.com.
So again, kind of crazy lighting, but I just wanted to say that despite the fact that Mike Pence, former Vice President Mike Pence, will not be voting for Kamala Walz, which I think is a goddamn shame, I still consider him as an actual hero, because if he had not had the guts to stand up and do what was right, things could have gone incredibly, dangerously different. So I just want to say Mike Pence is a hero. You know what? He did the right thing, and that was very heroic.
The rioters breached the Capitol at 2:13 p.m. Quote, staff Mark Meadows was notified of the violence at the Capitol by 2 p.m. and likely earlier. The testimony further establishes that Mr. Meadows quickly informed the president and that he did so before the president issued his 2:24 p.m. tweet criticizing Vice President Pence for not having, quote, courage to do what needed to be done. Here is what the president wrote in his 2:24 p.m. tweet while the violence at the Capitol was going on.
Donald J. Trump at Real Donald Trump. Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth, which you'll never get from me.
And here is what the rioters thought.
Nothing but a traitor, and he deserves to burn with the rest of them.
So it's all escalated after Pence. What happened? Did Pence Pence didn't do what we wanted.
Pence voted against Trump.
Okay, and that's when all this started?
Yep. That's when we marched on the Capitol. We've been shot at with rubber bullets, tear gas.
And we will never, ever forget!
Apparently,
Capitol, just be respectful.
Justice is coming.
And White House Deputy Press
Justice is coming.
Capitol.
apparently, everybody's real simple. Pence betrayed us, which apparently everybody knew he was going to, and the president mentioned it like 5 times when he talked. You can go back and watch the president's video.
This is our Capitol. Just be respectful to him. There's 4 million people coming in, so there's a lot of control. We love you guys. We love the cops.
It's only a matter of time. Justice is coming.
Although the President's Chief of Staff, Mark Meadows, has refused to testify before this committee, Mr. Meadows' aide, Ben Williamson, and White House Deputy Press Secretary Sarah Matthews testified that Mr. Meadows went to the dining room near the Oval Office to tell the President about the violence at the Capitol before the President's 2:24 p.m. tweet. In future hearings, you'll hear more about exactly what was happening in the White House at that time.
Followed him into that little corridor hallway. I saw him walk into Outer Oval. I maybe took a step into Outer Oval and then left. And I don't know where he went outside of that, but it looked like he was headed in the direction of the Oval Office.
You know, we had all talked about at that point about how it was bad and the, situation was getting out of hand. And I know Ben Williamson and I were conferring, and we thought that the president needed to tweet something immediately. And I think when Kayleigh gave us that order of don't say anything to the media, I told her that I thought the president needed to tweet something. And then I remember getting a notification on my phone, and I was sitting in a room with Roma and Ben, and we all got a notification. So we knew it was a tweet from the president, and we looked down, and it was a tweet about Mike Pence.
I believe I had sent him a text saying that we may want to put out some sort of statement because the situation was getting a little hairy over at the Capitol. And then it was common for, after I would text him, I would just go down and see him in person.
You went down to speak with Mark Meadows after this. What was that conversation?
Very brief. I went down and told him the same thing I have in the text that I can recall. And I don't remember anything that was said between us other than I told him that. And to my recollection, he immediately got up and left his office.
Our investigation found that immediately after the president's 2:24 p.m. tweet, the crowds both outside the Capitol and inside the Capitol surged. The crowds inside the Capitol were able to overwhelm the law enforcement presence, and the vice president was quickly evacuated from his ceremonial Senate office to a secure location within the Capitol complex. By 2:24 p.m., the Secret Service had moved Vice President Pence from the Senate chamber to his office across the hall.
The noise from the rioters became audible, at which point we recognized that maybe they had gotten into the building.
Then, President Trump tweeted, "Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth."
It was clear that it was escalating and escalating quickly. So then when that tweet, the Mike Pence tweet, was sent out, I remember us saying that that was the last thing that needed to be tweeted at that moment. The situation was already bad, and so it felt like he was pouring gasoline on the fire by tweeting that.
30 seconds later, rioters already inside the Capitol opened the East Rotunda door, just down the hall. And just 30 seconds after that, rioters breached the crypt, one floor below the Vice President.
The Secret Service couldn't control the situation and do their job of keeping him safe.
At 2:26 p.m., Secret Service rushed Vice President Pence down the stairs.
I think they had been trying to figure out whether they had a clear route to get us to wherever it was that they wanted to move us to.
We moved pretty quickly down the stairs and through various hallways and tunnels to the secure location. Upon arriving there was further discussion as to whether or not we were going to leave the Capitol complex or stay where we were.
Vice President Pence and his team ultimately were led to a secure location, where they stayed for the next 4.5 hours, barely missing rioters a few feet away.
The president tweeted at me by name, calling me out the way that he did. The threats became much more specific, much more graphic, and included not just me by name, but included members of my family by name, their ages, our address, pictures of our home.
For the PBS NewsHour, I'm Amna Nawaz.
Trey Grayson, as someone who has overseen the chair, Benny Thompson, taking a seat along with other members of this 9-member committee. And it looks like they are going to get underway, so we will go to Chairman Thompson.
The Select Committee to investigate the January 6 attack on the United States Capitol will be in order. Without objection, the chair is authorized to declare the committee in recess at any point. Pursuant to House Deposition Authority Regulation 10, the chair announces the committee's approval to release the deposition material represented during today's hearing. Good afternoon. This is almost no idea more un-American than the notion that any one person could choose the American president. No idea more un-American. I agree with that, which is unusual because former Vice President Mike Pence and I don't agree on much. These are his words, spoken a few months ago about Donald Trump's attempt to pressure the former vice president, pressure him into going along with an unlawful and unconstitutional scheme to overturn the 2020 election and give Donald Trump a second term in office that he did not win. Today, the Select Committee is going to reveal the details of that pressure campaign. But what does the Vice President of the United States even have to do with a presidential election? The Constitution says that the Vice President of the United States oversees the process of counting the Electoral College votes, a process that took place on January 6, 2021. Donald Trump wanted Mike Pence to do something no other vice president has ever done. The former president wanted Pence to reject the votes and either declare Trump the winner or send the votes back to the states to be counted again. Mike Pence said no. He resisted the pressure. He knew it was illegal. He knew it was wrong. We're fortunate for Mr. Pence's courage on January 6th. Our democracy came dangerously close to catastrophe. That courage put him in tremendous danger. When Mike Pence made it clear that he wouldn't give in to Donald Trump's scheme, Donald Trump turned the mob on him, a mob that was chanting, "Hang Mike Pence," a mob that had built a hangman's gallows just outside the Capitol. Thanks in part to Mike Pence, our democracy withstood Donald Trump's scheme and the violence of January 6th. But the danger hasn't receded. Led by my colleague, Mr. Aguilar, Today, we'll lay out the facts for the American people. But first, I'll recognize my colleague from Wyoming, Ms. Cheney, for any opening statement she'd care to offer.
No disrespect, I'm fast forwarding before time.
Demanding not just
this week that President Trump said I had the right to overturn the election. But President Trump is wrong. I had no right to overturn the election. The presidency belongs to the American people and the American people alone. And frankly, there is no idea more un-American than the notion that any one person could choose the American president.
what the president wanted the vice president to do was not just wrong, it was illegal and unconstitutional. We will hear many details in today's hearing, but please.
President Ronald Reagan and George H.W. Bush. He was appointed by the latter to serve on the U.S. Court of Appeals for the Fourth Circuit, where he served from 1991 to 2006. He provided critical advice for Vice President Pence regarding the role of the Vice President in the joint session of Congress shortly before that fateful moment. He's written that the Vice President does not have the power to select the next President of the United States. He's also written that contrary theory espoused by one of his own former law clerks was, quote, incorrect at every turn. We're also joined today by one of the people who was with Vice President Pence on January 6th. Greg Jacob was counsel to Vice President Pence. He conducted a thorough analysis of the role of the Vice President in the joint session of Congress under the Constitution, the Electoral Count Act, and 230 years of historical.
Fast forwarding, this day was 4 hours and 20 minutes.
And reading things that suggested that he had a significant role to play on January 6th in announcing the outcome of the election. He told me that he had been first elected to Congress in 2000 and that one of his earliest memories as a congressman was sitting in on the 2001 certification, and he recalled that Al Gore had gavelled down a number of objections that had been raised to Florida. And he asked me mechanically, how does this work at the joint session? What are the rules? And I told the Vice President that, in fact, I had a fairly good idea of how things work, that actually there aren't rules that govern the joint session, but what there is a provision of the Constitution that's just one sentence long, and then an Electoral Count Act that had been passed in 1887. And I told the Vice President that I could put a memo together for him overnight that would explain the applicable rules.
So, Mr. Jacobs, when you looked at this theory, what did you conclude?
So we concluded that what you have is a sentence in the Constitution that is inartfully drafted. But the Vice President's first instinct when he heard this theory was that there was no way that our framers, who abhorred concentrated power, who had broken away from the tyranny of George III, would ever have put one person, particularly not a person who had a direct interest in the outcome because they were on the ticket for the election, in a role to have decisive impact on the outcome of the election. And our review of text, history, and frankly just common sense all confirmed the Vice President's first instinct on that point. There is no justifiable basis to conclude that the Vice President has that kind of authority.
Thank you, Mr. Jacobs. We will hear more today about how, despite this conclusion by you and other top legal advisors, the former president used this discredited theory in his campaign to pressure the Vice President to decide the outcome of the presidential election. I now recognize the gentlewoman from Wyoming, Ms. Cheney, for questions.
Thank you very much, Mr. Chairman. Judge Ludig, thank you as well for being here with us today. You issued a very important statement earlier today, which I urge all Americans to read. And I'd like to ask you, Judge, about one of the sentences in your statement and ask if you could explain to us the significance of it. You say, had the Vice President of the United States obeyed the President of the United States, America would immediately have been plunged into what would have been tantamount to a revolution within a paralyzing constitutional crisis. Could you elaborate on that for us, Judge?
So no disrespect to Judge Ludig, but I actually sped this up and cut out a lot of his pauses because for some reason he was speaking exceptionally slow. So I just sped it up a little bit.
Thank you, Madam Vice Chairman. That passage in my statement this morning referenced the most foundational concept in America, which is the rule of law. Thus, as I interpret your question, you are asking about that foundational truth of these United States, which we call America. The foundational truth is the rule of law. That foundational truth is, for the United States of America, the profound truth. But it's not merely the profound truth for the United States. It's also the simple truth, the simple foundational truth of the American Republic. Thus,
in my view, the hearings being conducted by this select committee are examining that profound truth, namely the rule of law in the United States of America. The specific question, of course, before you and before the nation, not before me, is whether that foundational rule of law was supremely violated on January 6, 2021. Now, to the question specifically that you asked, Madam Vice Chair, I believe that had Vice President Pence obeyed the orders from his president and the President of the United States of America during the joint session of the Congress of the United States on January 6, 2021, and declared Donald Trump the next President of the United States, notwithstanding that then President Trump had lost the Electoral College vote as well as the popular vote in the 2020 presidential election. That declaration of Donald Trump as the next president would have plunged America into what I believe would have been tantamount to a revolution within a constitutional crisis.
Now I'm fast forwarding a bunch more. As I said, this was many hours, so I'm just trying to get a good understanding overall.
To make a very important 2 points. The fact that Mayor Giuliani seemed to admit that the theory was wrong did not stop him from going before the crowd just a few hours later on January 6th and saying the exact opposite. Here's Mayor Giuliani's speech at the Ellipse rally on January 6th.
We're here just very briefly to make a very important 2 points. Number one, every single thing that has been outlined as the plan for today is perfectly legal. I have Professor Eastman here with me to say a few words about that. He's one of the preeminent constitutional scholars in the United States. It is perfectly appropriate, given the questionable constitutionality of the Election Counting Act of 1887, that the Vice President can cast it aside, and he can do what a president called Jefferson did when he was Vice President. He can decide on the validity of these crooked ballots.
Crooked? Now, you're the
crooked one. Or he can send it back to the legislatures, give them 5 to 10 days to finally finish the work.
And here's what Dr. Eastman said in his speech at the Ellipse on January 6th.
And all we are demanding of Vice President Pence is this afternoon at 1 o'clock, he let the legislatures of the state look into this so we get to the bottom of it and the American people know whether we have control of the direction of our government or not.
Even Dr. Eastman knew his theory didn't hold water. Mr. Jacob, you discussed and even debated this theory at length with Dr. Eastman. Did Dr. Eastman ever tell you what he thought the U.S. Supreme Court would do if it had to decide this issue?
Yes. We had an extended discussion, an hour and a half to 2 hours on January 5th. And when I pressed him on the point, I said, John, if the vice president did what you were asking him to do, we would lose 9-0 in the Supreme Court, wouldn't we? And he initially started, well, I think maybe you would lose only 7-2. And after some further discussion, acknowledged, well, yeah, you're right, we would lose 9-0.
I appreciate that. In our investigation, the Select Committee has obtained evidence suggesting that Dr. Eastman never really believed his own theory. Let me explain. On the screen, you can see a draft letter to the president from October 2020. In this letter, an idea was proposed that the vice president could determine which electors to count at the joint session of Congress. But the person writing in blue eviscerates that argument. The person who wrote the comments in blue wrote, quote, the 12th Amendment only says that the president of the Senate opens the ballots in the joint session and then, in the passive voice, that the votes shall then be counted. The comments in blue further state, nowhere does it suggest that the president of the Senate gets to make the determination on his own. Judge Ludig, does it surprise you that the author of those comments in blue was in fact John Eastman?
Yes, it does, Congressman. But let me, watching this unfold, let me try to unpack what was at the root of what I have called the January 6th.
Baldly false statement about being in alignment, purported alignment with the vice president, despite all of the predicate that you indicated had gone before about their respective positions? Is that effectively what happened?
I interpret the statement as false. I'll let you figure out who sent it out. When Mark Short contacted you, he was upset. Is that what you said?
He clearly was not pleased.
Tell us what he said.
What's the process for putting out a statement for a meeting where only 2 people were in the room?
Did he ask you to retract the statement?
No, I think it went right to what's the process for putting out a statement for a meeting when only 2 people were in the room.
And he clearly disagreed with the substance, though, right? Because he said the vice president doesn't agree with this.
Trying to think.
This witness, whom the FBI affidavit refers to as W1, stated that other members of the group talked about things they did that day, and they said that anyone they got their hands on, they would have killed, including Nancy Pelosi. W1 further stated that members of the Proud Boys said that they would have killed Mike Pence if given a chance. We understand that congressional leaders and others were evacuated from the Capitol complex during the attack. We'd like to show you what happened after the vice president was evacuated from the Senate.
The Select Committee has obtained never-before-seen photos from the National Archives that show Vice President Pence sheltering in a secure underground location as rioters overwhelmed the Capitol. At 4:19 p.m., Vice President Pence is seen looking at a tweet the president had just sent, a tweet asking the rioters to leave the Capitol.
After that man waited to see if Mike Pence and Nancy Pelosi would be murdered, he decides to tweet.
After 4.5 hours spent on working to restore order, the vice president returned to the Senate floor to continue the certification of electors.
So Vice President Pence was a focus of the violent attack. Mr. Jacob, did the vice president leave the Capitol complex during the attack?
He did not.
Can you please explain why the vice president refused to leave the Capitol complex?
When we got down to the secure location, Secret Service directed us to get into the cars, which I did. And then I noticed that the vice president had not. So I got out of the car that I had gotten into, and I understood that the vice president had refused to get into the car. The head of his Secret Service detail, Tim, had said, I assure you we're not going to drive out of the building without your permission. And the vice president had said something to the effect of, Tim, I know you, I trust you, but you're not the one behind the wheel. And the vice president did not want to take any chance that the world would see the vice president of the United States fleeing the United States Capitol. He was determined that we would complete the work that we had set out to do that day, that it was his constitutional duty to see through, and that the rioters who had breached the Capitol would not have the satisfaction of disrupting the proceedings beyond the day on which they were supposed to be completed.
Let me see if I understand this right. You were told to get in the cars, and how many of the vice president's staff got in the cars while he did not?
Most of us.
During our investigation, we received testimony that while the Vice President was in a secure location within the Capitol complex, he continued the business of government. We understand that the Vice President reached out to congressional leaders, like the Acting Secretary of Defense and others, to check on their safety and to address the growing crisis. In addition, the Vice President's Chief of Staff, Mark Short, made several calls to senior government officials. Here's Mr. Short's testimony regarding his call with Representative Kevin McCarthy.
He indicated that he had some conversation. I don't recall whether it was with the president or somebody at the White House, but I think he'd expressed frustration that not taking the circumstances as seriously as they should in that moment.
So Mr. McCarthy indicated he'd been in touch with someone at the White House, and he conveyed to you that they weren't taking this as seriously as they should. Yes. You have to answer yes or no. Yes. Okay.
While the Vice President made several calls to check on the safety of others, it was his own life that was in great danger. Mr. Jacob, did Donald Trump ever call the Vice President to check on his safety?
He did not.
Mr. Jacob, how did Vice President Pence and Mrs. Pence react to that?
With frustration.
Mr. Jacob, immediately before you and the Vice President were evacuated to a secure location within the Capitol, you hit send on an email to John Eastman explaining why his legal theory about the Vice President's role was wrong. You ended your email by stating that, quote, "Thanks to your bullshit, we are now under siege." We'll take a look at that email. Now, Dr. Eastman replied, and this is hard to believe, but his reply back to you was, "The siege is because you and your boss," presumably referring to the Vice President of the United States, "did not do what was necessary to allow this to be aired in a public way so the American people could see for themselves what happened." Mr. Jacob, later that day, you wrote again to Dr. Eastman. Let's show that email on the screen. In that email, you wrote, and I quote, "Did you advise the President that in your professional judgment, the Vice President does not have the power to decide things unilaterally?" And you ended that email saying, "It does not appear that the President ever got the memo." Dr. Eastman then replied, "He's been so advised." And he ends his email with, quote, "But you know him, once he gets something in his head, it's hard to get him to change course," close quote. Mr. Jacob, when Dr. Eastman wrote, "Once he gets something in his head, it's hard to get him to change course," did you understand the he in that email to refer to the President of the United States?
I did.
I know your pain. I know you're hurt. We had an election that was stolen from us. It was a landslide election, and everyone knows it, especially the other side. But you have to go home now. We have to have peace. We have to have law and order. We have to respect our great I know your pain. I know you're hurt.
And Mr. Jacob, did you hear from Dr. Eastman further after the riot had been quelled? And if so, what did he ask?
Late that evening, after the joint session had been reconvened, the Vice President had given a statement to the nation saying that violence was not going to win, freedom wins, and that the people were going to get back to doing their work. Later that evening, Mr. Eastman emailed me to point out that, in his view, the Vice President's speech to the nation violated the Electoral Count Act, that the Electoral Count Act had been violated because the debate on Arizona had not been completed in 2 hours. Of course, it couldn't be since there was an intervening riot of several hours. And that the speeches that the majority and minority leaders had been allowed to make also violated the Electoral Count Act because they hadn't been counted against the debate time. And then he implored me, now that we have established that the Electoral Count Act isn't so sacrosanct as you have made it out to be, I implore you one last time, can the Vice President please do what we've been asking him to do these last 2 days, suspend the joint session, send it back to the states.
And we'll show you the text of that email, which Dr. Eastman wrote at 11:44 p.m. on January 6th. So after the attack on the Capitol and after law enforcement had secured the Capitol, he still wrote, as you described, quote, "So now that the precedent has been set that the Electoral Count Act is not quite so sacrosanct as was previously claimed, I implore you to consider one more relatively minor violation and adjourn for 10 days to allow the legislatures to finish their investigations." So even after the attack on the Capitol had been quelled, Dr. Eastman requested, in writing no less, that the vice president violate the law by delaying the certification and sending the question back to the states. Is that correct, Mr. Jacob?
It is.
Did you eventually share Dr. Eastman's proposal with Vice President Pence?
Not right at that time, because the vice president was completing the work that it was his duty to do. But a day or two later, back at the White House, I did show him that final email from Mr. Eastman.
And what was Vice President Pence's reaction when you showed him the email where Dr. Eastman, after the attack on the Capitol, still asked that the vice president delay certification and send it back to the states?
He said, that's rubber room stuff.
I'm sorry, Mr. Wood. He said it's rubber room stuff?
Yes, Congressman.
What did you interpret that to mean?
I understood it to mean that after having seen play out what happens when you convince people that there is a decision to be made in the Capitol legitimately about who is to be the president and the consequences of that, that he was still pushing us to do what he had been asking us to do for the previous 2 days, that was certifiably crazy.
We know that the vice president did not do what Dr. Eastman requested because he presided over the completion of the counting of electoral votes late in that evening.
The number of electors appointed to vote for President of the United States is 538. Within that whole number, a majority is 270. The votes for President of the United States are as follows. Joseph R. Biden, Jr. of the state of Delaware has received 306 votes. Donald J. Trump of the state of Florida has received 232 votes. The whole number of electors appointed to vote for Vice President of the United States is 538. Within that whole number, a majority is 270. The votes for Vice President of the United States are as follows. Kamala D. Harris of the state of California has received 306 votes. Michael R. Pence of the state of Indiana has received 232 votes. The announcement of the state of the vote by the President of the Senate shall be deemed a sufficient declaration of the persons elected President and Vice President of the United States, each for the term beginning on the 20th day of January, 2021, and shall be entered together with the list of the votes on the journals of the Senate and the House of Representatives.
Mr. Jacob, we heard earlier that you and the vice president and the team started January 6th with a prayer. You faced a lot of danger that day, and this is a personal question. But how did your faith guide you on January 6th?
My faith really sustained me through it. I, down in a secure location, pulled out my Bible, read through it, and just took great comfort. Daniel 6 was where I went, and in Daniel 6, Daniel has become the second in command of Babylon, a pagan nation, but he completely faithfully serves. He refuses an order from the king that he cannot follow, and he does his duty consistent with his oath to God. And I felt that that's what had played out that day.
It spoke to you?
Yes.
At the end of the day, Mark Short sent the vice president a text message with a Bible verse. Here's what he told the select committee.
At 3:50 in the morning, when we finally adjourned and headed our own ways, I remember texting the vice president a passage from 2 Timothy chapter 4, verse 7 about, I fought the good fight, I finished the race, I've kept the faith.
With a prayer, and ended his day with a Bible verse. I've fought the good fight, I've finished the race, I've kept the faith. The only one to date who has opined on whether the president was involved in. Dr. Eastman pled the fifth 100 times. Finally, let's hear from a federal court judge, the only one to date who has opined on whether the president was involved in criminal activity. Page 36 of Judge Carter's ruling says, quote, based on the evidence, the court finds it more likely than not that President Trump corruptly attempted to obstruct the joint session of Congress on January 6, 2021. Page 40 of the ruling says, quote, based on the evidence, the court finds that it is more likely than not that President Trump and Dr. Eastman dishonestly conspired to obstruct the joint session of Congress on January 6, 2021. And page 44, Dr. Eastman and President Trump launched a campaign to overturn a democratic election, an action unprecedented in American history. Their campaign was not confined to the ivory tower. It was a coup in search of a legal theory. Mr. Jacob, what would have happened to our democracy if Vice President Pence had gone along with this plan and certified Donald Trump as the winner of the 2020 election?
So there would have been short-term and long-term effects. The short-term I previously described, a constitutional jump ball situation, political chaos in Washington, lawsuits, and who knows what happening in the streets. And you would have had the Vice President of the United States having declared that the outcomes of these state elections were incorrect. So for all of those reasons, there would have been significant short-term consequences. But in the long term, we would have established a situation where a vice president would have asserted that one person could have the authority to determine the outcome of an election, which is antithetical to everything in our democracy. It's antithetical to the rule of law. And so it would have been significant impacts, both in the short and the long term.
Judge Ludig, in the statement you released earlier today, you wrote that the efforts by President Trump to overturn the 2020 election were, quote, the most reckless, insidious, and calamitous failures in both legal and political judgment in American history. What did you mean by that?
Exactly what I said, Congressman.
Thank you, Judge. Thank you, Mr. Jacob.
CatLoveDreamingPeach.com.